So, if it's for the purpose of facilitating flight, then that is also considered while committing. Next, they look at the policy purpose of the first judge's interpretation method. Strict interpretation was originally to soften the draconian penal provisions such as the death penalty, and shouldn't apply today. So here, criticizing the, I guess, the old interpretation style of the judge as opposed to the Dreiger's modern approach. It's also interesting that they're broadening their context so much that they're actually critiquing the interpretation style of the alternative view. So, but they do mention that if there is reasonable doubt, it should still always be resolved in the favor of the accused, though in this case, while committing in a contextual interpretation, there's no reasonable doubt of what it should be, and that is a single transaction. So anything that continues the illegal domination of the victim as per the purpose of creating first-degree murder, and as similar to the case law, is while committing. And thus, the Paré in this case should be guilty of first-degree murder. Next, we'll look at the harm principle, and this is John Stuart Mill arguing that the only purpose for which power can be rightfully exercised over any other member of civilized community against his will is to prevent harm to the other. And so his own good, either physical or more, is not sufficient warrant. So there is no justification in threatening someone with criminal, violent punishment because it's for their own good. It can only be to prevent harm for others, harm against others. And here Mill is arguing against the idea that a broader perspective of morality should be used to determine criminal law. Certainly morality is going to help decide what is harm to others, and we still have that today. But what he is saying is that it shouldn't be decided because God said so. We need evidence, we need reason, we need thought, and we need to get away from superstition and decide what is actually harming another person. Don't threaten me with criminal sanctions for my own good. I have absolute autonomy over my own body, and government power through criminal law to achieve moral ends is wrong. And this eventually led to people agreeing with him in certain circumstances, and the creating limits on criminal law. So in the late 60s, the Committee on Homosexual Offenses and Prostitution decided that they aren't actually hurting anyone, and thus there should be no criminal law against it, which led to the famous Devlin and Hart debate, deciding, or debating whether criminal law should serve individual interests, societal interests. How does morality fit into the institution of criminal law? So according to the report that decriminalized homosexuality, they echoed what John Stuart Mill was saying, and they said the criminal law should be to preserve and protect, preserve public order and decency, protect citizens from what is offensive or injurious. Offensive is a great line there. To provide sufficient safeguards against exploitation and corruption of others, particularly the vulnerable, but not to intervene in the private lives of citizens. I like that. Devlin here is taking perhaps arguing for the majority, and says that morality is what, or common morality is what holds the community together, and without it there would be a disintegration of the community. And so it is okay to use criminal law to enforce a common morality in order to keep society integrated. Now, how do you decide what's moral and what's not? He says that a feeling of disgust is helpful in decision in deciding what is moral and what's not. So if you feel it's immoral, then that's enough to perhaps create a law against it and enforce that law. So he also adds that the suppression of vice and other subversive activities is for the good of society. So here, kind of taking a community approach as opposed to an individual rights approach. Hart, on the other hand, thought that thought is needed before we turn to morality. So we need evidence and thought and a reasoned estimate of damages. What are the damages of these actions? And that's more important than feelings of morality. And he lists, burning old women at the stake because we thought we had a feeling that they were performing witchcraft. So is the practice that offends moral feeling harmful, independent of the repercussions of the general moral code? Is the practice that offends moral repercussions of the general moral code? What about the repercussions on the moral code? Is it really true that failure to translate this item into criminal law? Okay, so do actions that offend the general moral code, I guess, what are the repercussions of those actions? And are they so harmful that they need to be translated into criminal law? Are they so harmful that they would jeopardize the whole fabric of our society? So we need to look at that and decide that if we're going to use criminal law in order to outlaw something. It's nice. Hart says, it's kind of a funny line here, morality, what crimes may be committed in thy name. And so the feeling and morality is not a very reasoned and well thought out approach to deciding criminal law. The prologue to this was that the law against homosexual acts were repealed in England in 1967. Crimes of buggery and gross indecency do not apply to consenting persons over the age of 21 in 1969. And this is Trudeau's famous quote, "The state has no place in the bedrooms of the nation." 1988, the law against intercourse for people under the age of 18 years old is enacted. In 1995, it's repealed as unconstitutional. And in 2004, we have the reference to the Supreme Court of Canada, and they decide that the federal government does have the power to create same-sex marriage. And that is
Property, week 3.